10C, destitute children. Destitute children, a destitute child means a child under 18. A destitute child is 0 to 17, who is in a state of want or suffering due to lack of sufficient food, clothing, or medical or surgical care, and does not fit within the definition of an abused or neglected child, and is without any parent or caretaker available to sufficiently care for him. So again, destitute child is how old? Under 18, 0 to 17, the same as a PINS. Only the Commissioner of Social Services may originate an article under 10B, destitute children, by filing a petition alleging the child is a destitute child. The Commissioner of Social Services who accepts the care and custody of the child appearing to be a destitute child shall provide for such child as authorized by law, including but not limited to 389 Social Services, and shall file a petition pursuant to this section within 14 days upon accepting the care and custody of the child. So one more time, it's only the Commissioner of Social Services who can originate under Article 10B, destitute children. They're the only ones, the Commissioner of Social Services, by filing the petition is the only way they can originate in Article 10B, the Commissioner of Social Services, by filing the petition alleging the child is a destitute child. And the Commissioner of Social Services who accepts the care and custody of the child appearing to be destitute shall file the petition to this section within 14 days upon accepting the care and custody of such child. The petition in Article 10C, destitute children, the petition shall be filed in the family court located in the county where the child resides or is found. So the petition shall be filed in the family court located in the county where the child resides or is found. However, upon motion of any party or the child's attorney, the court may transfer a petition filed under this article to a county the court deems to be more appropriate under circumstances, including but not limited to a county located within a jurisdiction where the child is domiciled or has another significant nexus. The petition shall contain and allege upon information and belief A, the manner, date, and circumstances under which the child became known to the petitioner. B, child's date of birth if known. C, that child is a destitute and the basis for the allegation. D, identity of the parents in question. E, whether parents are living or deceased. F, the whereabouts and last known address for parents if known. G, identity of the caretaker or interested adult if known. H, the efforts, if any, made prior to filing the petition to prevent removal of the child from home. I, the efforts, if any, made prior to the filing of the petition to allow the child to return or remain home. One more time of what the petition shall contain and allege upon information and belief: the manner, date, and circumstances which the child became known to the petitioner, the child's date of birth, the child is destitute, the identity of the parents, whether the parents are living or dead, the whereabouts and the last known address of the parents, the identity of the caretaker or interested adults, the efforts, if any, were made to prevent the removal, or the efforts, if any, were made to allow the child to return or remain home. The petition shall also contain a notice in conspicuous print providing that if a child remains in foster care for 15 of the most recent 22 months, the agency may be required by law to file a petition to terminate parental rights. So again, the petition shall contain a notice in conspicuous print saying that if the child remains in foster care for 15 of the most recent 22 months, the agency may be required by law to file a petition to terminate parental rights. Service of the summons and petition under the Article 10C, destitute children, shall be made by delivering a true copy to the person summoned at least 24 hours before the time stated for appearance. So service again, Article 10C, destitute children, service shall be made at least 24 hours before time stated for appearance. 1095 says no fact-finding hearing may commence under this Article 10B, destitute children, unless the court enters a finding that all parties are present at the hearing and have been served with a copy of the petition. However, that if any party is not present, that the court may proceed if every reasonable effort has been made to effect service. So again, 1095 says no fact-finding hearing in 10B, destitute children, shall commence unless the court enters a finding that all the parties are present at the hearing and have been served with a copy of the petition. And if they're not present, that the court can proceed if every reasonable effort has been made to effect service. The court shall sustain the petition and make a finding that a child is destitute if, based upon a preponderance of the competent material and relevant evidence presented, the court finds the child meets the definition of destitute child. If the proof does not conform to specific allegations of the petition, the court may amend the allegations to conform with the proof if no party objects. One more time, the standard of proof in the destitute child Article 10C is based upon a preponderance of the evidence of the material, competent, and relevant evidence. And the court shall dismiss the petition if it finds that the child is not destitute or aid of the court is not required, and if applicable, return the child who was placed in the temporary care of the Commissioner of Social Services to his parent, caretaker, or interested adult, provided that if the court finds the child may be in need of protection, the court may request the Commissioner of Social Services to conduct a child protective investigation and shall state the grounds for the finding. If the court sustains the petition, it may immediately convene a dispositional hearing, or may adjourn the proceeding for further inquiries to be made. However, that if a petition pursuant to Article 6, permanent termination of parental rights, or Article 7, surrogate's court, has been filed, the court shall consolidate the dispositional hearing with hearing 1069, custody or guardianship with relatives or suitable person, unless consolidation would not be appropriate. So one more time, it says if the court sustains the petition, it may immediately convene a dispositional hearing or may adjourn the proceeding for further inquiries to be made. However, that if a petition pursuant to Article 6, permanent termination of parental rights, and that's by a person seeking custody of guardianship of the child, or an Article 17 surrogate's courts, and that's by a person seeking guardianship of the child, has been filed, the court shall consolidate the dispositional hearing with